If your family had to settle your estate next month, would they be in court or would everything transfer cleanly, privately, and quickly? I help families avoid probate in 30 days or less, not after someone dies, but before. And the truth is this, avoiding probate isn't about drafting documents, it's about building a system. Today, I'm going to walk you through why probate drags on for months, sometimes years, why most estate plans still end up in court, and how I structure estates so families can settle everything quickly and privately, especially when property is owned in multiple states. Because if you own property in more than one state, you don't have a paperwork problem, you have a structure problem. In order to understand what probate really is, let's define it clearly. Probate is the court-supervised process of transferring assets after death. It exists for one reason: to retitle assets that were still in your individual name. That's it. If something is titled in your name alone or with no beneficiary or with no survivorship, it goes through probate. In Georgia, even a straightforward probate can take 6 to 12 months. If real estate is involved, longer. If there's family disagreement, much longer. If there's property in another state, now you're dealing with ancillary probate, which is a second court proceeding in another jurisdiction. And here's what most people don't realize. Probate isn't just slow, it's public, it's administrative. It creates liquidity pressure. Your children may have to advance legal fees, maintain property, pay taxes, cover utilities, deal with court filings, all while grieving. That's not what most people want. Most people say, I just don't want to make things hard on my kids, but that requires structure, not just documents. Here's the uncomfortable truth. Many people who have a will still go through probate. Because a will does not avoid probate, a will directs probate. That's a big difference. A will is instructions to the court. If everything is still in your individual name, the court must retitle it. Now, let's talk about trusts. Many people create revocable living trusts, which is good, but here's the mistake. They create the trust and never fund it. So what happens? The trust exists, the binder looks beautiful, the documents are signed, but the assets are still in the individual's name. That means probate. Then, there's the multi-state problem. If you own a home in Georgia, a beach property in Florida, a mountain cabin in North Carolina, each state controls the real property within its borders. If those properties are in your individual name, your family may have to open up probate in multiple states, multiple attorneys, multiple court systems, multiple delays. This is where estate planning becomes estate systems. Before we get back to the 30-day framework, I want to address something important. Putting an estate plan in place in 30 days is powerful, but keeping it aligned over the next 10, 15, 20 years, that's where most plans break. Life changes, children grow up, trustees move, assets shift, property gets sold and new property gets purchased, and most people never update their documents. That's exactly why we recently launched a private YouTube membership. It's not public content, it's structured information. Inside that membership, I answer the questions I get constantly. Do we put vehicles in the trust? How do we coordinate life insurance? What happens if we refinance? When should we amend the trust? What is redemption? Why does my trust mention my grandparents? Instead of emailing back and forth, you get clear, private explanations on demand. It's part of how we keep your estate system aligned after those first 30 days. Because building the system is step one, maintaining the system is what protects your family long term. Now, let's go back to how we actually get this done in 30 days. So how do I structure estates to avoid probate quickly? There are 5 components. Number 1, we build the correct trust structure. For most married couples, that means a properly drafted revocable living trust designed to hold assets during life and govern them at death. But drafting is just step 1. Step 2, we properly fund the trust. This is where most plans fail. We retitle real estate, brokerage accounts, non-qualified investments, business interests into the trust. If the trust owns it, probate is not required because nothing needs to be retitled by the court. The successor trustee simply steps in and acts. No judge, no waiting, no public file. Number 3, we eliminate multi-state probate for multi-state property owners, which many of my clients are. We ensure real estate in other states is titled properly. When the trust owns property in multiple states, there's no ancillary probate. The successor trustee has authority immediately. And that's how you avoid the 2-state, 3-state nightmare. Number 4, we coordinate beneficiary designations. This is critical. Some assets should not be retitled into the trust, retirement accounts, certain life insurance policies. Instead, we align beneficiary designations with the trust structure because beneficiary forms, they override your will and trust. If those are misaligned, you can unintentionally create probate or tax issues. coordination matters. Number 5, we preserve liquidity. This is the part no one talks about. Even if probate is avoided, families can still get stuck if they lack liquidity. We structure cash reserves, life insurance, access provisions, so the surviving spouse or trustee has immediate authority and access. The result? In most properly structured estates, administration begins immediately and can be functionally settled very quickly. Not because we rushed, but because the system was built correctly. If you've been putting this off because you think it's going to take forever, or it's going to be complicated, or it's going to drag on for months, it doesn't have to. With the right process, a complete operational probate avoidance estate system can be in place in 30 days or less, especially for married couples with $1 million in assets. You don't have a paperwork problem, you have a sequencing problem. And that's how we structure and solve those problems. If you're ready to start thinking about estate planning and start finishing it, schedule a consultation, because structure is peace of mind, and peace of mind shouldn't take a year.